The nature of a fatwa is widely misunderstood by Western people, many of whom know only of the fatwa issued by the Ayatollah of Iran against author Salman Rushdie in 1989. At its heart, a fatwa is a religious ruling or religious guidance on a question put by a Muslim person to a cleric. Under some circumstances, however, a fatwa can call upon the faithful to punish or carry out actions towards people who are considered to be acting immorally. Fatwas were being used for this purpose during the 1990s in Bangladesh, particularly resulting in punitive physical violence towards some women. The applicant in this matter was a Bangladeshi man who had married a Hindu woman in Bangladesh and who had converted to Hinduism to do so. Apostasy, or giving up one's religion, is considered a serious matter within Islam. The applicant was concerned for his safety and that of his wife, so he moved away from his home village and ultimately sought asylum in Australia. The application, however, was not clear-cut. The evidence before the tribunal was that even if a fatwa was issued in Bangladesh, it was usually issued by a fairly low-level local cleric and was rarely enforced. And then the Bangladesh High Court declared that fatwas of this type were unlawful. That declaration was appealed to the appellate court, which issued a stay of the High Court decision, which was in force when the Refugee Review Tribunal made its decision. Ultimately, the tribunal decided that the applicant did not have a well-founded fear of persecution because he had been able to live safely away from his home village in Bangladesh and because the local authorities were likely to protect him from any violence associated with the fatwa. The applicant appealed, but the full federal court agreed with the tribunal, saying even if all due regard had been paid to the stay of the High Court declaration that fatwas were illegal, the conclusion that the appellant had at the date of the tribunal's decision a fear of persecution well founded on his marriage and conversion to Hinduism was far from the only conclusion reasonably available to the tribunal. In this case, we see the Australian court taking a nuanced approach to the concept of a fatwa, trying to genuinely understand it in context rather than uncritically treating a fatwa as an instrument of persecution.